Another power of the executive, Commander-in-Chief powers. Section 18, Article 7 states that the President shall be the Commander-in-Chief of all armed forces of the Philippines, and whenever it becomes necessary, he may call out such armed forces to prevent or suppress lawless violence, invasion, or rebellion. Next sentence, and very important. In case of invasion or rebellion, duhara, invasion or rebellion, when the public safety requires it, he may, for a period not exceeding 60 days, suspend the privilege of the writ of habeas corpus, or place the Philippines or any part thereof under martial law. Within 48 hours from the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus, the President shall submit a report in person or in writing to the Congress. The Congress, voting jointly by a vote of at least a majority of all its members in regular or special session, may revoke such proclamation or suspension, which revocation shall not be set aside by the President. Upon the initiative of the President, the Congress may, in the same manner, extend such proclamation or suspension for a period to be determined by the Congress, if the invasion or rebellion shall persist and public safety requires it. The Congress, if not in session, shall, within 24 hours following such proclamation or suspension, convene in accordance with its rules without any need of a call. The Supreme Court may review, in an appropriate proceeding filed by any citizen, the sufficiency of the factual basis of the proclamation of martial law, or the suspension of the writ, privilege of the writ, or the extension thereof, and must promulgate its decision within 30 days from its filing. A state of martial law does not suspend the operation of the Constitution, nor supplant the functioning of the civil courts or legislative assemblies, nor authorize the conferment of jurisdiction on military courts and agencies over civilians, where civil courts are able to function, or automatically suspend the privilege of the writ. The suspension of the privilege of the writ shall apply only to persons judicially charged for rebellion or offenses inherent in or directly connected with invasion. During the suspension of the privilege of the writ, any person thus arrested or detained shall be judicially charged within 3 days, otherwise it shall be released. Okay, explain. Commander-in-Chief powers. What constitute Commander-in-Chief powers? 1. He may call out such armed forces to prevent or suppress lawless violence, invasion, or rebellion. 2. He may suspend the privilege of the writ of habeas corpus. And 3. He may proclaim martial law over the entire Philippines or any part thereof. The President is the Commander-in-Chief of all armed forces of the Philippines. The ability of the President to require a military official to secure prior consent before appearing before Congress pertains to a wholly different and independent species of presidential authority. The Commander-in-Chief powers of the President. By tradition and jurisprudence, the Commander-in-Chief powers of the President are not encumbered by the same degree of restriction as to that which may attach to executive privilege or executive control. Ayun rada sila. So, katong sa NERI, Commander-in-Chief powers dito. Outside explicit constitutional limitations, the Commander-in-Chief clause vests in the President as the Commander-in-Chief absolute authority over persons and actions of members of the armed forces. Such authority includes the ability of the President to restrict the travel, movement, and speech of military officers, activities which may otherwise be sanctioned under civil law, from the case of Godani versus Senga, 2006. Graduated powers. So, may meaning ng graduated powers? It is still under Commander-in-Chief powers, Section 18, Article 7. Graduated powers. Under Section 18, Article 7 grants the President as Commander-in-Chief a sequence of graduated powers from the most to the least benign. These are 1. calling out power. 2. Power to suspend the privilege of the writ of habeas corpus. And 3. Power to declare martial law. And the exercise of the latter two powers, ang power to suspend the privilege of the writ of habeas corpus and power to declare martial law, the Constitution requires the concurrence of two conditions, namely, an actual invasion or rebellion, and that public safety requires the exercise of such power. Okay, so duha ra ang need. There should be actual invasion or rebellion, and that the public safety requires the exercise of such power. However, these conditions are not required in the exercise of calling out power. The only criterion is that whenever it becomes necessary, the President may call the armed forces to prevent or suppress lawless violence, invasion, or rebellion. From the case of San Lakas versus Executive Secretary, 2004. Calling out powers. This is merely a police measure meant to quell disorder. As such, the Constitution does not regulate its exercise radically. State of rebellion. Since the Constitution did not define the term rebellion, it must be understood to have the same meaning as the crime of rebellion in the Revised Penal Code. In determining the existence of rebellion, the President only needs to convince himself that there is probable cause or evidence showing that, more likely than not, a rebellion was committed or is being committed. To require him to satisfy a higher standard of proof would restrict the exercise of his emergency powers. From the case of Lagman versus Medialde, 2017. Martial law is Mindanao. Suspension of the privilege of the writ of habeas corpus. The requisites for suspension of the privilege of the writ of habeas corpus are: 1. There must be actual invasion or rebellion, and 2. Public safety requires it. Note that the privilege of the writ is suspended, not the writ itself. The writ is an order from the court commanding a detaining officer to inform the court that 1. He has the person in his custody, and 2. His basis for detaining that person. What are the effects of the suspension of the privilege? 1. The suspension of the privilege of the writ applies only to persons judicially charged, should be read as one who is suspected of complicity in, for rebellion or offenses inherent in, or directly connected with invasion. From Section 18, Paragraph 5, Article 7, where such persons suspected of the above can be arrested and detained without warrant or of arrest, and the suspension of the privilege does not make the arrest without warrant legal, but the military, in effect, enabled to make the arrest anyway, since with the suspension of privilege there is no remedy available against such unlawful arrest or arbitrary detention. Third, the arrest without warrant is justified by the emergency situation and the difficulty in applying for a warrant considering the time and the number of persons to be arrested. Justified. The crime for which he is arrested must be one related to rebellion or invasion, and to others the suspension of the privilege does not apply. During the suspension of the privilege of the writ, any person thus arrested or detained shall be judicially charged within 3 days or otherwise shall be released. From Section 18, Paragraph 6, Article 7, where the effect thereof is only to extend the periods during which he can be detained without a warrant. When the privilege is suspended, the period is extended to 72 hours. What happens if he is not judicially charged nor released after 72 hours? The public officer becomes liable under the Revised Penal Code, Article 125 thereof, for delay in the delivery of detained persons. And third, the right to bail shall not be impaired when the privilege of the writ of habeas corpus is suspended. Excessive bail shall not be required. Article 3, Section 13. The suspension of the privilege does not destroy petitioner's right or cause of action for damages for illegal arrest and detention and other violations of their constitutional rights. From the case Aberca versus Ver, 1988. The President may exercise the power to call out the armed forces immediately, independently of the power to suspend the privilege of the writ of habeas corpus and to declare martial law, although of course it may also be a prelude to a possible future exercise of the latter powers, as in this case. The case of Lagman versus Medialde, 2017. What are the 4 ways for the proclamation of martial law or the suspension of the privilege of the writ of habeas corpus to be lifted? 1. Lifting by the President himself. 2. Revocation by Congress. 3. Nullification by the Supreme Court. And 4. By operation of law after 60 days. Declaration of martial law and the suspension of the privilege of the writ of habeas corpus. Extension. What are the requisites in proclaiming martial law? 1. There must be an invasion or rebellion under Section 18, Article 7, Executive Department. And 2. Public safety requires the proclamation of martial law all over the Philippines or any part thereof. The power to declare martial law and to suspend the privilege of the writ of habeas corpus involve curtailment or suppression of civil rights and individual freedom. Thus, the declaration of martial law serves as a warning to citizens that the Executive Department has called upon the military assist in the maintenance of law and order, and while the emergency remains, the citizens must, under pain of arrest and punishment, not act in a manner that will render it more difficult to restore order and enforce the law. The case of Lagman versus Medialde, 2017. The following cannot be done by a proclamation of martial law. Under Section 18, Article 7. 1. Suspend the operation of the Constitution. 2. Supplant the functioning of the civil courts and legislative assemblies. And 3. Confer jurisdiction upon military courts and agencies over civilians where civil courts are able to function. What is meant by open court doctrine? Open court doctrine is where civilians cannot be tried by military courts if civil courts are open and functioning. Martial law usually contemplates a case where the courts are already closed and the civil institutions are already crumbled, that is, theater of war. The case of Olaguer versus Military Commission, 1987. And lastly, what cannot be done by a proclamation of martial law is automatically suspend the privilege of the writ of habeas corpus. The President must expressly suspend the privilege. Role of Congress during suspension of the privilege of the writ of habeas corpus. Role of Congress during declaration of martial law. Okay. So, ano ang role sa Congress? Section 18, paragraph 1 and 2 of Article 7. 1. Congress may revoke the proclamation of martial law or suspension of the privilege of the writ of habeas corpus before the lapse of 60 days from the date of suspension or proclamation. 2. Upon such proclamation or suspension, the Congress shall convene at once. If it is not in session, it shall convene in accordance with its rules without need of a call within 24 hours following the proclamation or suspension. 3. Within 48 hours from the proclamation of the suspension, the President shall submit a report in person or in writing to the Congress, meeting in joint session of the action he has taken. And 4. The Congress shall then vote jointly by a majority of all its members with the following option. 1. To revoke such proclamation or suspension. When it is revoked, the President cannot set aside or veto the revocation as he normally would in cases of bills, or pwede sila maka-revoke, or they can extend it beyond the 60-day period for its validity. The Congress can only so extend the proclamation or suspension upon the initiative of the President. The period need not be 60 days. It could be more, as Congress would determine based on the persistence of the emergency, if they choose to extend. Okay. Note that if the Congress fails to act before the measure expires, it can no longer extend it until the President again redeclares the measure. What? The Congress extends the measure, if the Congress extends the measure, but before the period of extension lapses, the requirements for the proclamation or suspension no longer exist, the Congress can lift the extension, since the power to confer implies the power to take it back. So, we're done with the role of Congress during the declaration of martial law. We go now to the role of the Supreme Court under Section 18, Paragraph 3 of Article 7. What's the role of the Supreme Court? 1. The Supreme Court may review, in an appropriate proceeding filed by any citizen, the sufficiency of the factual basis of 1. The proclamation of martial law or the suspension of the privilege of the writ, or 2. The extension thereof. It must promulgate its decision thereon within 30 days from its filing. In reviewing the sufficiency of the factual basis of the proclamation or suspension, the Court considers only the information and data available to the President prior to or at the time of the declaration. It is not allowed to undertake an independent investigation beyond the pleadings. On the other hand, Congress may take into consideration not only the data available prior to, but likewise events supervening the declaration. Thus, the power to review by the Court and the power to revoke by the Congress are not only totally different, but likewise independent from each other, although concedingly, they have the same trajectory, which is the nullification of the presidential proclamation. Needless to say, the power of the Court to review can be exercised independently from the power of revocation of Congress. From the case of Lagman versus Medialde, 2017. Role of the Supreme Court in petition for habeas corpus. So, inside roles of the Supreme Court. 1. If a person is arrested without a warrant for complicity in the rebellion or invasion, he or someone else in his behalf has the standing to question the validity of the proclamation or suspension. Before the Supreme Court can decide on the legality of his detention, it must first pass upon the validity of the proclamation or suspension. RA 7055 of 1991, an act strengthening civilian supremacy over military by returning to the civil courts the jurisdiction over certain offenses involving members of the armed forces of the Philippines, other persons subject to military law, and the members of the Philippine National Police, repealing for the purpose certain presidential decrees. So, RA 7055 provides that when these individuals commit crimes or offenses penalized under the RPC, or other special penal laws or local government ordinances, regardless of whether civilians or co-accused, victims, or offended parties, which may be natural or juridical persons, they shall be tried by the proper civil court, except when the offense, as determined before arraignment by the civil court, is service-connected, in which case it shall be tried by a court-martial. The assertion of military authority over civilians cannot rest on the President's power as Commander-in-Chief or in any theory of martial law. As long as civil courts remain open and are regularly functioning, military tribunals cannot try and exercise jurisdiction over civilians for offenses committed by them and which are properly recognizable or cognizable by civil courts. From the case of Olaguer versus Military Commission, 1987. Question: do letters of instruction and presidential decrees issued by the President under the 1973 Constitution during martial law form part of the laws of the land. Letters of instruction are presumed to be mere administrative issuances, except when conditions set out in Garcia Padilla versus Indrili exist. To form part of the law of the land, the decree, order, or letter of instruction must be 1. Issued by the President in the exercise of his extraordinary power of legislation, as contemplated in Section 6 of the 1976 Amendments to the Constitution, and 2. Whenever either A. In his judgment, there exists a grave emergency, or a threat or imminent danger thereof, and B. The interim Batasang Pambansa, or the regular National Assembly fails or is unable to act adequately on any matter for any reason that his judgment requires immediate action. The case of PASEI versus Torres, 1993.